afternoon, and hello, GovCon HR friends. Welcome to Season 3, Episode 4 of the GovCon HR Round-Up. Welcome back to our large base of loyal listeners out there, and obviously always welcome to any first-time listeners today. You've been missing a lot of fun over the past 2.5 years.
Dang right.
My name is Joe Young. I am the founder and general manager of GovCon Pay, now division of iSolved HCM. We are the only outsourced payroll and HR services provider focused exclusively on serving the government contracting marketplace. And we are coming to you live from the offices of Berenzweig, Leonard, LLP here in Tysons Corner, Virginia, from the studios of BLC Digital Strategies, their media affiliate, and under the support of our producer, Mr. Todd Castleberry. Before we get started in introductions, I do always want to reach out and recognize our loyal sponsor, the folks from Berkshire Associates. Berkshire are HR compliance experts with over 50 years of experience in providing compliance services and technology for organizations looking to build their ideal workforce through compliant non-discrimination services, workforce analytics, and pay equity expertise. So special welcome to any Berkshire Associate clients who are joining us. But great to be back together. It was just Seth and I on the last episode.
Yeah. I was out. Yep.
Gallivanting, traveling, whatever you're doing. But why don't, for any of our first-time listeners, proud to introduce the founding partners of Berenzweig Leonard, Mr. Seth Berenzweig and Mr. Declan Leonard. Quick introductions, gentlemen.
Hi, I'm Seth. I'm relieved to see Declan here because there were violent protests outside the building with Declan here. So,
and my family.
Yes. So glad to see that Declan's back in the saddle.
Yeah, I'm trying to think where I was last month. I can't even remember. Anyways, somewhere. I'm sure I was somewhere. Maybe playing golf. I didn't want to tell Joe because I know he'd come with me. And I'm Declan Leonard, also managing partner here at Berenzweig Leonard. I head up our firm's employment law practice, working with HR folks like you all watching here today.
Well, it is good to be back, and it was March because we didn't have an episode in April, so it's good to be back here in May. Today, it's kind of a breaking news edition of the Roundup.
Lots to cover, yeah.
Literally, I think you and the team have been adding things to the agenda today, since we even met yesterday to kind of prep. So we're going to touch in really two particular areas, some changes and some things that are kind of breaking news and in movement, kind of in the federal side. And then we're going to, Declan, you're going to speak specifically about some things that are specifically happening here in the state of Virginia. We know we have listeners from all over the country. Even though you may not be headquartered here in Virginia, it does impact if you have employees here, which a lot of our government contracting clients do. But also, we also think some of these things could be a bellwether or an indication of other things that could be coming to other areas. So we think it's important to touch on those as they may be, like I said, an indicator to maybe some changing things in the landscape. So with that as an intro to our topics today, Seth, let's start off with you. There was another federal update on DEI recently. For those of you who are loyal listeners, we know we've covered a lot of DEI over the past year. It's kind of an inside joke. It's kind of things, if you know, you know. Trump issued an executive order in March titled Addressing DEI Discrimination by Federal Contractors. But there was another development. Can tell us what we're talking about now?
Okay, so there's been a lot of activity. As we know, this administration does not like DEI, and they have.
We've covered that pretty well.
From what I've heard, but anyway, following this executive order, there is now a new FAR clause that's being dropped in, FAR 52.222-90. Which prohibits contractors from engaging in any racially discriminatory DEI activities, imposes new information reporting requirements, is required to be included in all contracts, including those for commercial products and services for which delivery or performance is in the United States. And it has to be flowed down. This is effective immediately, and the deadline for flowing down is just in a couple of weeks by July 24th, with very limited exceptions. And there has been an announcement also at the Justice Department that in addition to the most severe sanctions, which can include up to and including debarment, that the Justice Department has also issued a memorandum stating that they're also going to deem this to be a potential violation of the False Claims Act. And the False Claims Act has criminal implications, which means that there could be indictments that could be issued by the government if there's a violation of this DEI directive.
So the running joke on the Roundup series is, can we ever make it through one session, one of these webinars without talking about DEI?
Right.
And it's not that just that we're going back to the well and saying, well, there's nothing else to talk about. The reason why we talk about it so much is because they targeted it. The Trump administration targeted DEI, diversity, equity, and inclusion early on in the administration. And I think some people thought, is this something that they're focused on? And then they'll go to the next thing.
Is it
and the
lip
next
service?
thing. Yeah. And this is truly one thing that they have never let go. And in fact, continue to ratchet up. It's going to be, you have to sign your certification when you're applying for your payment as a government contractor or face liability under the Federal False Claims Act. But they keep taking it to the next level. Now we've got a FAR clause. I mean, do you know how, the FAR clauses don't come about very easily.
Yeah.
And now we've got a FAR clause that implements it, not only to the prime contractor, but also to the subcontractor.
Right.
They mean business when it comes to this stuff. They mean business with diversity, equity, inclusion. They don't believe that you should have any preferences based on race, gender, ethnicity, things of that nature. And so if you have any policies, we've been doing DEI audits for our clients for a long time now, since this was first introduced. If you've got any policies that give any preferences, racial, gender, ethnicity,
inclusion initiatives. Yeah.
I mean, first off, those words, diversity, equity, and inclusion, if they show up anywhere, and I guarantee they're using AI to look at websites,
yes,
scrub them, because if you can come up with something different, then that's probably what you should do.
Yeah, and those are the ultimate kisses of death: debarment and criminal prosecution. So it's hot on the issue.
And as a practical matter, we talked about this as we walked in here. And I want to kind of be really direct on this, because I've heard our clients, and maybe it's just because they've been doing it for so long, people are still talking about affirmative action plans, and we're over 50 employees, and we have to do an affirmative action plan. Your recommendation to clients now is not only do you not need to do those, you should not be doing affirmative action plans. You're setting yourself up for being in violation of this. So
take them down.
I've had clients keep saying, well, we need this info because we have to do affirmative action plans. And so you
take them
they
down.
should not be being done right now.
No, that's
I've heard some people saying, hey, we're doing it because, hey, the next administration, they may come back and we're going to need to go back for 3 years and show them. But the recommendation of the Roundup is these are things that activities you should not be doing anymore.
Cannot be doing.
Be doing anymore.
Because by definition, they're affirmative action. They're affirmative action in terms of preferences. And so if you do get audited and they come in and you're saying, well, look, I've always done this, I'm not filing them. So no harm, no foul. We said not to file them anymore. But if you're just collecting that data, that means you're documenting what affirmative actions you have taken to hire persons of particular races, of particular genders. That alone constitutes what this administration, you can fight it all you want, you can disagree with their position, but if you do work for the federal government, you got to play by each administration's rules. This current administration believes that those are discriminatory on their face. Yep.
And illegal and potentially criminal. Criminal violation.
Yeah.
We made that as clear as we possibly could.
Yeah, we have
with the sole exception of veterans and individuals with disabilities.
Yes. Yep.
Wonderful.
Okay.
And we're this could be like lightning round because we've got so much
a lot to do.
So let's wrap up on the federal side. This is not specifically directed to our HR folks, but obviously has such a big impact on the government contracting with some of these bills coming through Congress. So why don't we go there next?
So important news. Senator Mike Lee and Congressman Glenn Rothman have introduced bills entitled Ending Discrimination in Government Contracting Act in the Senate and the House, which, if passed, would effectively eliminate the Women-Owned Small Business Program and the SBA's 8A Business Development Program, socially and economically disadvantaged preferences. It's not yet law, but it is moving along. It is in the works. As we sit here today, we don't know whether or not it's going to pass, but this is a really big deal. Additionally, the bill calls for eliminating disadvantaged business enterprise goals, repealing minority business development, prohibiting executive agencies from factoring race, ethnicity, or sex into contract and award decisions, prohibiting primes from factoring race, ethnicity, or sex into decisions with subcontractors. This is something that is going to flow down if it gets enacted. We'll keep a close eye on it. This has not been followed in the news. I was talking to a veterans group in Bethesda a week ago, and I was mentioning this. And again, this doesn't affect vets per se, and it doesn't affect small businesses per se, but relative to 8A and these kinds of set-aside programs, they were shocked. So this is not something that you're going to hear about in mainstream media, but it's out there and you need to keep an eye on.
I mean, this is huge in my opinion. How many companies, Seth, have we seen, have we represented that have built their business model and their success on the 8A program, on set-aside programs that I think are going to probably go by the wayside. Now, the interesting thing, though, you know, I mean, time could be the enemy of this effort here because we've got the midterms coming up. I mean, before you know it, we'll have the midterms. This has to make its way through Congress. I mean, I guess the president could always try to do some of this stuff through executive order, even past the midterms. But if the midterms don't go the way of the Trump administration, some of this stuff could be stymied.
Get stuck.
And so, you know, this is, it's important to say that this is very early on. Congress works very much at a snail's pace. And so that this is not a foregone conclusion, but it's definitely, I mean, it's really just an offshoot of the whole DEI efforts here. So, before we hit state, we got more breaking news. Yes, we've got OPM today.
Oh, I'm going to let you run with it. I don't even have it on my notes.
It's so new that it didn't even make your outline today. Okay, so let's talk about this. And many people might have seen this in the news this morning, but OPM, Office of Personnel Management, who kind of handles all the back office for the federal government, they have introduced a template non-disclosure agreement, an NDA. Most people know it as that nomenclature, NDA, at first, it was going to be federal employees to sign these so that they do not release, basically to avoid leaks. There's a frustration with the current administration that too much stuff is being leaked. And so they want federal employees, whether it's all federal employees, whether it's selected federal employees who maybe have access to certain information. But what's interesting is they've also included contractors. Because remember, I mean, they look at government contractor employees as really just an extension of the federal workforce. And so what they've done is they said it will allow agencies to use what has become a standardized NDA confidentiality agreement. And so what's interesting about this is who knows what it's going to be used for. They talk about a couple of different uses. To protect personally identify information, PII. But then they had this phrase that says it also is going to protect sensitive government information, including operational plans, you know, things of that nature, personnel records and other protected materials. And so it's really as broad as anybody wants to. I mean, if you want to keep any information out about some of the landmarks in DC, like the Arch that's under proposal, if you want to keep any of that stuff out, have a contractor sign an NDA under this template that OPM has put out. So I think this is an important thing. And the reason why HR really should sort of focus on this is I could see a scenario. Most of your employees are working on site. I could see a scenario. They throw it in front of you, say, hey, sign this before you do your work today.
And before they share it with HR.
Yeah, not all employees are going to be like, well, first I've got to go back to headquarters and run it up the flagpole or whatever. So HR's got to be very, very involved in this. They've got to be very proactive and really get word out to the workforce. Hey, you may be presented with this. If you are, you need to let management know before you sign anything. You're not authorized to sign anything until we give you that okay. Now, if they don't sign this stuff, again, you go down the same road of potential termination for convenience on a contract, suspension, debarment. So the government always holds the purse strings and they always hold the power when it comes to these relationships. Something to be aware of. We'll see how frequent or often they use these, because this is really hot off the presses as of this morning.
Interesting.
Breaking news.
Yeah, and I bet that a lot of HR directors haven't even really noticed that in the news cycle. But that's something that not only do they need to be aware of it, but they would want to look at the language before it's signed. because who knows what language they're going to ultimately put in the form to have their employees sign off on.
Yeah, and you're not
like no template language has been released or anything.
I think they did release one this morning. I didn't get a chance to look at it, but I think they did. It could be one for consideration because usually they'll throw something out
they
there.
Can throw guidance.
But this ain't going to be like the private sector. This ain't going to be like, hey, we've redlined your NDA. Like, you know,
I'll have my attorney call you.
That ain't got Todd Blanche is not going to be like, well, we'll accept this one, but we're not accepting this one. So, so this will be a take it or leave it situation. Yeah. Again, not a whole lot that HR can do other than be proactive, be aware, make sure you're communicating with your workforce.
Yeah.
So let's switch to Virginia.
I need a drink. No, just kidding.
There has been a lot. We've covered a lot of changes in Virginia here in the past year. Let's start with, as we covered, I know on a previous issue of the Roundup, we talked about the new laws around non-competes, how they were not applicable to low-wage employees making under $78,000. New language with regards to non-competes. So what does some of this new non-compete law restrict beyond that?
And it's seismic. And the stuff we're talking about here today is very consequential for companies and for HR. I'm guessing that most people know about it, but it's very important to continue to go through this because come July 1st, and Virginia does everything July 1st, which I think is so interesting because it's usually the week of the 4th of July. It's usually one of these slower weeks. And
nobody's around.
And yet all laws in Virginia, or most of them, go into effect come July 1st, you know, the middle of the year. And so you really, you know, cancel the beach trip or no, I'm just kidding. Just bring this stuff and have some interesting beach reading. But basically, let's jump into this. So non-competes, as you mentioned, Virginia has been whittling away on non-competes for a while. And remember, Virginia 5 years ago, 10 years ago, used to be a jurisdiction that really had no discernible employment laws. Now that has changed, and we'll talk about that, why that's changed here. But for the non-competes, basically they've whittled away. They said lower wage people don't have to be subject to non-competes. But what they did now, which I think is seismic, is they have said that come July 1st, for any non-compete that's entered into, so it's not already, you know, prior non-competes, anything July 1st or forward, prospectively. If you want to subject any employee, doesn't matter high earner or low earners can't be subjected, but highest earners in your company, it could be your chief growth officer, whatever, you have to couple that with severance pay in order for that non-compete to be enforceable if you then want to lay off an employee. So this applies when you're doing a layoff. If the employee resigns, that's not a problem. You can impose a non-compete. If you terminate them for cause, that also allows you to impose a non-compete. But let's face it, most separations other than resignations are just employers going through a layoff, going through it's rare that they go down the road.
Or not even wanting to characterize it as for cause.
Yeah, for cause has been like, people always,
gray.
It's so hard to fit in that definition. And up until like this type stuff, it's like, who cares? Why does it matter if you went down that road? There's no real legal significance. And what's interesting about it is the severance has to be negotiated at the time they're signing the non-compete. So you could have an employee that starts on July 1st, let's just say, and you're like, this is great. You're going to be our chief growth officer. You know, we want you here for the discernible future. But we're going to subject you to a non-compete. Oh, and by the way, because we have to, we're going to negotiate severance now. Like most severance is something that is back and forth,
totally
worked out.
It's a great way to start a relationship.
Exactly. And so I suspect, having done this for 30 years, I suspect most companies, first off, they're going to forget that they have to negotiate the severance at the front end. And so they're going to be like, well, we'll deal with severance later on. I believe that this will largely, over time, eradicate non-competes in Virginia for most employees. Yeah. Wow. Yep. And then everything will then boil back down to non-solicitations. Don't solicit our employees. Don't solicit our customers. We don't have enough time to jump into it, but even those in some respects are a little bit under attack. So, and it's not just, as you mentioned before, it's not just, okay, I'm not a Virginia-based employer, so why do I care? You may be a Maryland-based or a DC-based. You're going to have Virginia, or Huntsville, Alabama. I mean, anywhere. I mean, we're talking about like all of the focus areas,
Yeah.
Huntsville, Colorado. I mean, all of our
Our
clients have
Alaskan native
employees
firms that are out of Alaska, they all have
Yeah.
employees or headquarters here in
all over.
Virginia.
They have
Yeah.
people here.
So don't tune out just
Yeah.
because you say, "Oh no, I'm a so and so based company,"
Yeah.
because you may have ties to Virginia, but also this trend is not unique to Virginia. This trend, started obviously the famous one is California, where they outlawed non-competes generally. We didn't do quite the same thing in Virginia. I think it's more in practice that's what's going to happen over
The
time.
result. Yeah.
Yeah. So, and what it's going to do for HR is, and we continue to see that HR. Yeah, we're good. 7 minutes, they tell us. What's so important for HR is documentation. We say it until we're blue in the face. Documentation. Some companies still are not sending out termination notices after a termination meeting. Most termination meetings nowadays are not in person. They're on video. And then there's not that termination notice afterwards. And it doesn't have to be a long document, but it's going to be very important now to say, if you're going down the for cause route, you better say what is the for cause, and you better have the backup documentation, because that's the one way around this rule is if you terminate them for cause. That's messy, not going to be fun.
This is a huge change.
Yeah.
Huge. But wait, there's more.
But wait, there's more. The Virginia,
Yes.
legislator, is just staying very, very busy. So the other change with regards to the Virginia Wage Payment Act. So what is changed there?
So Virginia, much like many other states, if not the majority of states, have variations of what they call the Wage Payment Act. If you don't pay your employees their wages, then you could be subject to draconian litigation, including treble damages. You failed to pay your employee $10,000 on the way out the door. That now turns into $30,000 because of treble damages plus attorney's fees. So these laws are very potent. Virginia is no exception. So what happened though is this Virginia Wage Payment Act has been on the books for a couple of years now. But what was unclear is what constituted wages, and some courts were taking the position that it was very much just like your pay. Well, what they did was the legislator came out and said, no, they defined it as any remuneration an employer owes to an employee. So we're talking hourly wages, minimum wages, day rates, salaries, overtime wages, which is huge because you're already doing 1.5 times for overtime, and now trebling that. Commissions, tips, bonuses. I mean, bonuses, if you look at most bonus plans, it's like at the discretion of the company. Well, why wouldn't an employee roll the dice, get a lawyer, sue you for it, and said, I earned my bonus and I want not only my $25,000 bonus, but treble it. It's now $75,000.
And my attorney's fees.
And my attorney's fees. We're now looking at a small 5-figure turn into a low 6-figure. And they can run into general district court. Here in Virginia, the jurisdictional limit is $50,000, and it's sort of low hanging fruit. And I think it's gonna create a lot of activity in the HR world.
And I think that $50K is exclusive of fees, right?
It is, yeah.
So you could have $50,000 in a bonus dispute and another $50,000 in attorney's fees.
Yeah,
you're in a little district court with no formal discovery, and the next thing you know, you're in a whole hornet's nest.
Yeah, I mean, just a practical thing that HR deals with all the time. You say that you're going to pay out any unused but accrued paid time off, PTO. It's sometimes in your handbook. It's sometimes according to state law. Every state is a little bit different. And let's just say the employee has now gone a little bit disgruntled and said, I'm not giving you my laptop back. I don't have to give you my laptop back. And I missed the courier. They start playing games. I say this because we deal with this all the time. Well, good. We're not paying you your unused but accrued PTO. Well, now that used to be an easy purse string decision. There's some legal risk there.
Yeah.
Well, but whatever. I'll use my leverage to get my computer back. Well, now it potentially falls under this Virginia Wage Payment Act. That PTO could be trebled with attorney's fees and things of that nature. So it's really going to change the dynamic, I think, and who holds the power under some of these pay disputes.
In a state that used to not care about any of this stuff, it's been completely flipped upside down.
Yeah, and just to be clear, Virginia is not the only one that has wage payment acts.
Right.
All of the surrounding jurisdictions here do.
Yep.
DC's is very potent. Maryland's is very potent.
Yep.
I could go on and on because most of our clients have I mean, I'm doing employee handbooks with 26 state law addenda these days and things of that nature. So it impacts employees across the country.
Key takeaway today: the power of the treble.
Yeah, the power of the treble.
Yeah.
Yeah.
It changes the math real quick.
Yeah, because plaintiffs' attorneys are now very attracted to taking these cases.
Yeah.
And they can take them and bring them in general district court. You can be in and out in 6 weeks. I mean, literally, you can be in and out. You can do your first return, do potential trial. Most of them are going to settle, and as opposed to a year and a half in circuit court. So it makes economic sense for plaintiffs' lawyers to now take these cases.
Yeah. But wait, there's still more.
There's still more. We're still talking about wages. So now there's also new requirements for wage history and pay transparency.
Yeah, this started.
What do our HR folks need to know about that now?
Yeah. Whereas non-competes, you always think of, California voided out non-competes. Well, pay transparency really got famous through Colorado.
Yeah.
They kind of were at the forefront, which basically means, hey, you've got to, when you're advertising for a job, you've got to put in a good faith range of what the wage, what the salary is going to be. And it really, I mean, for government contractors, it presents an issue because what you're paying people really impacts your wrap rate, all of your internal dynamics of how you're bidding on a particular contract. And so it's caused a lot of confusion. But many states have now followed suit. And of course, Virginia did too. Virginia says you've got to put a good faith salary range. But what Virginia did, they took it one step further. They said now employees or applicants for jobs have a private right of action. Because let's say Colorado, in that particular case, the government would come in, step in and try to eradicate this. Now you can have an applicant for a job. They can be trolling Indeed or Monster or those other websites. And if they don't see a range in there, they can say, I tried to apply for this job. There was no range. And now I have a private right of action to go in. So unfortunately, yet another headache for HR to deal with as you're posting these things. And a lot of companies outsource this. You've got to police who your recruiters, your outside recruiters are. You've got to be really, really on top of that as you're going through this. So, and the other thing is wage history. You cannot.
Now, is that just for positions that are in Virginia or candidates if for Virginia? So as far as knowing what you have to put in the post. So you're putting the post on Indeed.
I know. And
is this for a job that's based in Virginia? You have to have the range. But what if it's not in Virginia, but you have a Virginia applicant?
It's a great question because you can't really, you can't say no Virginia employees need to apply because they tried to do that in Colorado. And Colorado said that's retaliation.
Or try to exempt yourself out of the local employment laws of Virginia, because if you're going to bring someone from Virginia, you have to follow the substantive employment laws of Virginia.
The point you just raised, Joe, just really underscores the fact that you really don't operate in any one state anymore. So to say I don't operate in Virginia, well, if you're advertising on Indeed,
you are.
People in Virginia are accessing Indeed.
Yeah, it could be a job in Huntsville, but if I apply in Virginia, you don't have the transparency. They're like, well, I don't have to put it in here. It's for a job down here, and then they get caught.
Yeah, and I know we're basically running out of time, but we got one more thing under this is wage history. When you're interviewing, you cannot now in Virginia ask about salary history. Prior salary history. You just cannot ask. You can ask them, hey, what are you expecting? What are you looking for? The thought behind it is it's premised on the fact that there has been wage discrimination over the years. And so by asking somebody what their last salary was, you're just perpetuating wage discrimination because, you might add to it a little bit, but that doesn't mean you're trying to pay them in accordance with what you believe the market is. You're relying on old history. So it makes it very difficult for people to really do the salary negotiation that used to happen a lot.
Yeah.
So if you didn't need a drink before the show, you definitely need one now.
That's right. Stock up for the 4th of July. It's going to be the 1st of July is going to be the new one.
Have a great summer.
Some more fun brought to you by the HR Podcast Roundup. Always, like I said, breaking news edition. Hopefully this probably was new information for many of you since literally some of the things came off the wire this morning. We hope, as always, that this news, this information was helpful. Hope it doesn't cause too much duress in anybody's day, as we maybe just added some new things for consideration to your already kind of busy and complicated world as GovCon HR professionals. But that's why we're here. We're trying to bring value and trying to make you what you do, the hard job you do, as easy as possible. Sorry we ran a little over today. We did cover a lot of information. But as always, we greatly appreciate you joining us. We look forward to our next session in June. Stay tuned. We may be, our typical date for the 18th may getting pushed back to the 25th. We'll get some information out on that. But again, thank you all so much for joining us. Enjoy your summer, and we look forward to seeing you in June.